My name is Chuck Smythe, and I'm the director of the Culture and History Department here at Sealaska Heritage. And I have a few little announcements before starting. First of all, I'd like to remind you that Celebration 2020 is coming up in June. That'd be June 10th through the 13th. And please put that on your calendar and tell all your family and friends and out-of-state visitors to come in the first week in June or the second week in June for that event. Also, there were a couple of handouts on the table. If you missed those, there'll be somebody in the back of the room who will have those, but those are needed for the lecture today. And also, we've mentioned that these lectures get posted on YouTube a couple of days after they're completed. So please subscribe to our YouTube channel. SHI has a YouTube channel now, and if you will remember to subscribe to that, that'll help us out a lot. And also, I always forget this myself, cell phones, better turn them off so they don't buzz. And at the conclusion of his talk, we will put a microphone down in the lower level there for people to ask questions. And if there's anyone that has any comments they would like to make, we welcome those. And but we like to put a microphone there so they're recorded well for our video. And also on the table is a schedule of our upcoming lectures. Please be sure you have those. So today we have David Case. I'm very pleased to welcome David Case to SHI in the Walter Soboleff building. I think this is the first time he's been here because he lives in Hawaii now. For over 35 years, David Case was an attorney representing and advising Alaska Native profit and for-profit boards, corporations, and tribal councils. His practice took him to remote Alaska Native communities from Ketchikan to Kotzebue and from the Aleutians to the Arctic. He also served as a Northwest Arctic Borough attorney for 15 years. During his career, David held positions with the Alaska Federation of Natives, the Alaska Native Foundation, the Department of Interior. The Alaska Federation of Natives honored David with the Denali Award in 1998 for dedication and service to the Alaska Native community. David has written law review and other scholarly articles and regularly spoken on Indigenous Alaskan issues. While an assistant professor of political science and Native studies at UAF, he wrote Alaska Natives and American Laws, published by the University of Alaska Press. Frequently cited by courts and scholars, the book analyzes the historical and ever-changing application of federal law to Indigenous peoples in Alaska. He and David Volok have co-authored the second and third editions of this book, the latter published in 2012. He credits several Tlingit leaders and mentors for his career and life in Alaska, including Clarence Antiquoquia, Gordon Jackson, Dennis Demmert, and Dr. Rosita Wuerl. In 1984 and 85, David served as counsel to the Alaska Native Review Commission and its Canadian Commissioner, the Honorable Thomas R. Berger, examining the implementation of the Alaska Native Claims Settlement Act. Before his retirement in 2011, he held the highest Martindale Hubble attorney rating of AV, which stands for preeminent, and was several times named an Alaskan super lawyer. We got to see what that's like. He is now completely retired from the practice of law and lives in Hawaii with his wife, Dorothy. There he has become an avid outrigger canoe paddle, and if you ask him, he'll tell you about serving on one of the first Hawaiian teams of over 70 paddlers. David believes that much like the indigenous peoples of Alaska, small-scale farmers in Hawaii are often marginalized and lack by larger political interests and lack effective access to and influence over governmental decisions that can adversely affect him. He now serves as the statewide secretary of the Hawaii Farmers Union United and its affiliated charity, the Hawaii Farmers Union Foundation, representing some 1,500 farmers and their supporters throughout 13 chapters in Hawaii. The union's diversified organization was purposely patterned along the lines of Alaska Native tribal, regional, and nonprofit corporations. So with that, I'm very pleased to welcome David to talk about this significant case in Alaska's history. Thank you.
Thank you, everybody, for being here. Anytime I give an address like this, I'm reminded of a time 20 or 30 years ago, everything is that long ago now, when I was a younger lawyer, giving a speech at the Captain Cook Hotel, I think. It was a room full of people. And I just launched into the speech, and a tall, distinguished Tlingit grandmother stood up. You know you're going to learn something when that happens. And she said to me, wait a minute, young man, our custom is to introduce ourselves. And so I gave an introduction, much like I think Chuck has given here, of my accomplishments, my background, and so forth. And she didn't seem to be too happy with that. She was okay. As I went on in time, I realized what she really wanted to hear was maybe something like this. My name is David Stanway Case. I am named after my great-grandfather, David Stanway. He came from England at 19 in 1859 and started Teachers College in Michigan. He graduated in 1861, just in time to join the Union Army. And he fought throughout the Civil War. My mother, Winifred Case, is from Little Rock, Arkansas. And she came north, met my father, Kenneth Case, and she always said that whenever she was asked where she was from, she lived to be 90, she was always from Little Rock. And she always said also that she was 21 before she realized that damn Yankee was actually 2 words. So I'm always aware of the differences and unique factors of our family lives and our backgrounds, and Tlingit people in particular are able to identify those in a few words in the recitation of their name and the clan affiliation. I have to do more, but thank you very much. What I'd like to talk to you today about, and I've actually looked at all the videographs of the prior lectures from Professor Langdon and Walter Echo Hawk and Chris McNeil. And I hope that this contributes to those lectures as well in your understanding of these matters. What I've handed out to you is what we're going to go through the words here of the principles boiled down in my mind as to what constitutes the source of federal Indian law as it relates to Alaska Natives and American Indians, or Indigenous peoples, as I would prefer to call them today. And the case we're going to talk about eventually is in Sah Quah. But before we get to that story, we will have to talk about some other things that are behind this case, or perhaps ignored by this case. My talk is titled "The Meaning of a Meaningless Case." And although Sah Quah had a lot of effect on the Tlingit people and Alaska Natives in general for decades, it is now consigned, I think, to the dustbin of history. Well, let's begin at the beginning. In 1789, the United States adopted the Constitution. And Article 1 of the Constitution lays out the powers of the legislature, the Congress, and provides that under Section 8, Clause 3, the Congress shall have the power to regulate commerce with foreign nations and among the several states and with the Indian tribes. Now you notice that there's some grammatical parallels here, with foreign nations, with Indian tribes, among the several states. So with suggests that these are separate institutions, foreign nations and the tribes. They are not among the several states. The other provision in the Article 1 that mentions the Indians is the Indians not taxed. And the Indians not taxed are referenced with respect to the way in which you calculate the numbers of people to be represented in the Congress. So all the free people in the United States are represented by their numbers, according to their numbers, by representative in the House of Representatives, excluding the Indians not taxed, who are not represented at all, and 3/5 of everybody else. They don't say who those people are, but they are the slaves. And so this is the clause in which Congress punts slavery and punts Indians to the future. The Civil War and maybe the Civil Rights Act have resolved the question of slavery, at least. It's not race relations in America. But nothing has really addressed the question of the Indians not taxed, even though they are now taxed, and their relationship with the United States, except for the Commerce Clause. The other part of the Constitution to realize is Article 6, which provides that the Constitution and laws of the United States, which will be made in pursuance thereof, are the supreme law of the land. The Constitution or laws of any state to the contrary notwithstanding. That means if Congress regulates commerce with Indian tribes, these states cannot do anything about that. It is not invidious discrimination based on race. It is a political relationship between the United States and the Indian tribes, and it is the supreme law of the land. So it doesn't matter if a state feels this is unfair or unequal, its laws cannot apply where Congress has acted. But that is not where federal Indian law actually comes from. These are 6 words in the United States Constitution. Regulate commerce with the Indian tribes. It says nothing about land rights, land claims, or indeed any other rights at all. It says something about the commercial relationships maybe between Indian tribes and the United States, where commerce will be regulated. But it says nothing about anything else. So where does the law that applies to the indigenous peoples of the United States come from? It comes from the common law. We've all heard of common law marriage. It's not quite as good as the real thing, but it's effective. But the common law is the law that is unique to the areas of the world that were controlled by the British Empire. It is the history of law in England. It is the law made by, eventually, courts out of their interpretation of the history and the relationships of people. And out of these relationships, which may not have any legal significance, a court will make a decision, and then that decision as to what that relationship means becomes the law. For example, years in the 19th century, there was a common law about where you could put your nets on the beach in southeast Alaska. And that law, even though there was no law that assigned you a place to put your nets, if you put them there for a period of time, courts would uphold your right to keep them there. That is the kind of thing the common law does. But it also has been up to the first middle of the 20th century, really, the common law was the origin of almost all the law that relates to Native Americans, the indigenous peoples. And these are laws made by judges, often individual judges in individual courts, and ultimately the United States Supreme Court. So the first real decision that came out of the United States Supreme Court, there are others a little bit before this, but that defined the rights of Indian tribes to property is in Johnson versus McIntosh. It's the second full page in the handout that you have. And I'm actually going to read it and read along, think about what's going on here in this paragraph. There are 6 words in the Constitution that relate to Indian tribes and their relationship. There are 356 words here, 456 words here, that in a twinkling decide the significant matter. On the discovery, let me back up. This case involves a contest over land title. The Illinois and McIntosh Indians had conveyed land, a lot of land, in 1776, to some folks who happened to be sympathizers with the British Crown. Well, you all know what happened. In 1776, the Revolution broke out, and these guys went back to England, taking their land title with them that they'd gotten from the Illinois and McIntosh Indians. And then after the Revolutionary War, the United States concluded a treaty with the same Indians for the same land. And they granted 11,000 acres of this land to Mr. McIntosh. So the question is, whose title is going to be controlled here and recognized in the United States courts? Johnson and Graham's lessee, from which the first name of the case is taken, or Mr. McIntosh, who derived his title from the United States. Well, I think you know the outcome, but let's see why. On the discovery of this immense continent, John Marshall says, the great nations of Europe were eager to appropriate to themselves so much of it as they could respectively acquire. Its vast extent offered an ample field to the ambition and enterprise of all, and the character and religion of its inhabitants afforded an apology for considering them as a people over whom the superior genius of Europe might claim an ascendancy. Remember, Walter Echo talked about the elements of these decisions that are 5 elements that demonstrate an unjust decision. The first is an apology. So now we're apologizing for what we're about to do. Something bad is about to happen. The potentates of the old world found no difficulty in convincing themselves that they made ample compensation to the inhabitants of the new by bestowing on them civilization and Christianity in exchange for their unlimited independence, the indigenous people's unlimited independence. But as the Europeans, they were all in the pursuit of nearly the same object. It was necessary, in order to avoid conflicting settlements and consequent war with each other, to establish a principle which all should acknowledge as the law, by which the right of acquisition, which they all asserted, should be regulated as between themselves, as between the Europeans that are contesting for the new lands. This principle was that discovery gave title to the government by whose subjects or by whose authority it was made, against all other European governments, which title might be consummated by possession. The wonderful thing about property law is you can divide property up into all kinds of ideas, and he's divided it into about 3 here in this sentence. You have the original occupants of the land who seem to have unimpeded title to it, the discoverer who by somehow discovering this land then acquires a title to the property, while it is yet in the possession of the Indians. So the indigenous peoples have been kind of converted to involuntary lessees here of the property. And as we will find out, there's only one buyer for their property. It is the United States or the government. Those relations which were to exist between the discoverer and the natives were to be regulated by themselves. What does that mean? Well, it usually means war. That's how you regulate things between yourselves if you dispute about who owns something between nations. The rights thus acquired being exclusive, no other power could interpose between them, and that is the United States now, by that sentence, has the exclusive right to acquire this land from the original inhabitants. In the establishment of these relations, the rights of the original inhabitants were in no instance entirely disregarded, but they were partly disregarded, but were necessarily to a considerable extent impaired. While the different nations of Europe respected the right of the natives as occupants, they asserted the ultimate dominion in themselves, and claimed and exercised as a consequence of this ultimate dominion a power to grant the soil while yet in possession of the natives. These grants have been understood by all to convey a title to the grantee subject only to the Indian right of occupancy. Now you've heard all about this with Walter Echohawk in the Teton case and Chris McNeil's discussion of the Tlingit and Haida settlement. There the land was granted to the United States, or taken by the president in the creation of the Tongass National Forest, while yet in possession of the indigenous peoples. And it was not until there was always a dispute about whether it was Aboriginal title in Alaska, but the U.S. Court of Claims had no problem with this. It held that there was Aboriginal title for the Tlingit and Haida Indians, and their possession was exclusive, and so they had to be paid for the taking of their land. And that is how this language plays out in real life. In this single paragraph or two, John Marshall turned the title, the original title of the Indian tribes to all of America into an exclusive right of use and occupancy. Now that's not without value. You can't get the oil out of Prudhoe Bay until you extinguish the right of use and occupancy of the Alaska natives. But it substantially diminishes the value of this property, including, as the Teton case held, there is no right to Fifth Amendment compensation for this kind of property that is not fee simple property. And all that happened in the course of a common law decision made by 5 justices of the United States Supreme Court. That's how Indian law is made. And most of the basic principles are established in the same way. Now, let's go on a little bit further. In 1831, John Marshall was on the Supreme Court for a long time. He had occasion to determine and look at the question of the scope of indigenous sovereignty, the right to self-government, as we might say today. It came up in two cases in the Cherokee Nation. I've only cited one here because for the element of time. But in Cherokee Nation versus Georgia, the state of Georgia nullified all the laws of the Cherokee Nation. The Cherokee Nation had a treaty with the United States that guaranteed them their reservation and the right to their own law and government. But Georgia passed laws that said this is all nothing, doesn't mean anything. Georgia's laws extend to the Cherokee Nation. That came to the United States Supreme Court, and the United States Supreme Court under John Marshall punted, said we don't have any jurisdiction, can't decide it, but it may well be doubted whether those tribes which reside within the acknowledged boundaries of the United States can with strict accuracy be denominated foreign nations. The Cherokees were arguing they were a foreign nation and couldn't be in front of the Supreme Court. They may, more correctly perhaps, be denominated domestic dependent nations. And that is the phrase that defines the scope of Indian sovereignty or indigenous sovereignty in America. All again by a common law decision. They occupy a territory to which we assert a title independent of their will, which must take point in effective and point of possession when their right to possession ceases. Kind of an echo of Johnson versus McIntosh. Worcester versus Georgia is the next case. Walter Echohawk really covered that. Now, in 1834, 3 years after this decision, the United States Congress passed another, there have been several of these, but the Indian Trade and Intercourse Act. Congress was concerned about the confrontation between the Indian people and the settlers, and among other things, and wanted to control commerce with the Indian tribes so that they could avoid this conflict. And so they enacted a statute in 1834 which defined the Indian country. That is, all the land to which the original Aboriginal title has not been extinguished. This is 1831, and there's a lot of that in America at that point. There's a lot of land where there have been no treaties or anything with the Indian tribes to determine their land or to acquire their lands. So this statute in 1834 says it's an act to regulate trade and intercourse with the Indian tribes and preserve peace on the frontiers. And so it being enacted, it acted a statute that all or that part of the United States west of the Mississippi River, that's everything west of the Mississippi River, and not within the states of Missouri and Louisiana or the territory of Arkansas, and also that part of the United States east of the Mississippi, not within any state, to which the Indian title has not been extinguished for the purposes of this act shall be taken and deemed to be the Indian country. This is a country where the title has not been extinguished, not a reservation necessarily, but it could be everything else in the country, all the way west of the Mississippi. This was in 1834. In 1867, the United States executed a treaty with Russia by which it acquired Russia's interests in Alaska. The treaty did not grant the United States Alaska. Russia had nothing, could not sell the United States Alaska. It could only sell its right as the discovering nation to acquire the land in Alaska from the indigenous peoples. And we always say everybody ignores this clause. It is Article 3 of the Treaty of Cession. You just think it doesn't exist because no court in the 19th century seldom cite this article. But just read it. They say there are no treaties with Alaska Natives. Well, there's a treaty about them. And it reads, the inhabitants of the ceded territory, according to their choice, reserving their natural allegiance, may return to Russia within 3 years, but if they should prefer to remain in the ceded territory, they may, with the exception of the uncivilized native tribes. Now let me tell you, uncivilized native tribes doesn't mean there's a civilized tribe and there's an uncivilized tribe in Alaska. At this point in time, all native people, if they had not abandoned their tribal relationships, were considered to be uncivilized. That was the definition. If you abandon your tribal relationships, you could become civilized and become a citizen. But as long as you maintained your tribal relations, there was a synonym. Tribal relations means you are uncivilized as a person and as an Indian, and not entitled to citizenship. You are among the Indians, not taxed. The uncivilized tribes will be subject to such laws and regulations as the United States may from time to time adopt in regard to the Aboriginal tribes of that country. I will suggest that the 1834 Indian Country Statute, which defines everything west of the Mississippi as being Indian country, now applies in Alaska in 1867. And Secretary Seward told Congress and the Cabinet exactly that the laws of the Indian people in Alaska are on the same footing as the indigenous peoples or the Indian peoples of the United States. This clause is ignored in most of the decisions that have been made in Alaska. All right, now, as part of the 1834 statute, the Indian Country Statute, at the very bottom of this page, we have Section 25. There's about 35 of these sections in this statute. Section 25 applies all the laws of the United States to white people or natives involved with white people committing crimes or doing activities within Indian country. But, provided the same shall not extend, in other words, the laws of the United States shall not extend to crimes committed by one Indian against the person or property of another Indian. That's an exception. The laws of the United States do not apply to Indians committing crimes against Indians in Indian country. And all of Alaska is within the scope of the statute, I would think, but the courts disagree. And all of the indigenous people in Alaska in 1867 should have been subject to that law, to have their own sovereignty and claims of government within themselves as to the punishment of any kind of crime. Well, between 1831, when John Marshall held that the Cherokee Nation were a domestic dependent nation, and later, the next year, when he held that laws of Georgia could not apply to the Cherokee Nation, most of the states ignored that. There was no other decisions being made, frankly, by the U.S. Supreme Court. And so the states and the territories acted as though they had jurisdiction over Native people. They would continually try indigenous peoples in their courts and sentence them to death or prison or whatever mattered. My source for this is Crow Dog's case by a scholar named Sidney Herring, written in 1994. It describes the history of this state enforcement of state law in spite of the federal law, which would seem to say the states had no jurisdiction. But that message didn't get across to the states and was resisted by them anyway. Herring also discusses in re Sah Quah, the topic of our discussion today. But before we get there, we need to go here. In 1883, on the next page, if you'll turn over the handout, Crow Dog, who was a traditional leader of the Brule Sioux tribe in the Dakota Territory, killed Spotted Tail. And Spotted Tail was the agency chief. He was the recognized chief. He was the peacemaker who had negotiated the treaties and so forth for the Sioux with the United States. And he was the guy who was responsible for the governance of the Brule Reservation. For whatever reason, this case is kind of ambiguous in some ways, Spotted Tail shot him and killed him. And so Spotted Tail was tried for murder in a federal court in the Dakota Territory. And he was convicted, and he was sentenced to hang. But this raised a significant question of who had jurisdiction here. In fact, so significant that Congress appropriated $1,000 to pay for the appeal of Crow Dog to the U.S. Supreme Court. And the U.S. Supreme Court took this argument then. And the argument was, this is Indian country. Crow Dog killed an Indian. They're both Indians. The 1834 Act doesn't apply. It does apply. They're not subject to the federal laws. They're only subject to the tribal law. Well, the unfortunate fact was the 1834 definition of Indian country had expired. The statute had lapsed. So let's see what the U.S. Supreme Court does with this. This is a couple of paragraphs here from Crow Dog. So this is the Supreme Court talking. In our opinion, the definition of the 1834 Act now applies to all the Indian country to which the Indian title has not been extinguished. Now, this is 1883, 1867, was a treaty, it's still Alaska, it's west of the Mississippi, should be the Indian country in Alaska, although that's not the topic of this case. within the limits of, has not been extinguished, within the limits of the United States, even when not within the reservation expressly set apart for the use of occupancy of Indians. Although much of what is now the United States has been acquired since the passage of the Act of 1834, and notwithstanding the formal definition in that act has been dropped from the statutes, the provisions were first enacted in Section 25 of the Indian Intercourse Act, that offenses committed by Indians against white persons and by white persons against Indians were enumerated and defined. And those by Indians against each other were left to be dealt with by each tribe for itself according to local customs. The policy of the government in that respect has been uniform. Now, I suggest to you that in 1884, Alaska became a territory of the United States, in which the policies of the United States, the uniform policies of the United States, should have been applied. They are uniform. And that means that it's Indian country. And that's not a reservation, but if there are indigenous peoples here that have disputes within their communities, those disputes belong to the Indian tribes to deal with. The tribes for whom the Act of 1834 was made were those semi-independent tribes whom our government has always recognized as exempt from our laws, whether within or without the limits of an organized state or territory in regard to their domestic government, left to their own rules and traditions, and with whom the governments, state and national, deal, with few exceptions only, in their national or tribal character and not as individuals. Now, I don't think they had any in mind that Alaska was a huge exception to this provision. The law of the United States then was that if you lived in Indian country and were an Indian, and your Aboriginal title had not been extinguished, you were subject to the laws of the tribe. Crow Dog was punished by the tribe. The day after this murder, he was brought before the tribal council, and according to Herring, his family was required to give Spotted Tail's family 6 blankets and a horse. But there's more to it. About 20 years ago, when I was teaching a class, a young woman raised her hand and she said, I'm the Brule Sioux. Do you know what really happened to Crow Dog? His family was banished from Sioux political life for 7 generations. Now, I haven't verified that claim, but I believe it's true from what she said. And it is a significant penalty for this crime. But even if it wasn't, 6 blankets and a horse was the decision of the tribal council as well. So that was Crow Dog's punishment. His writ of habeas corpus was granted. He was free from the sentence of death and lived a long and well-honored life back on the Sioux reservation. So now we get to Sah Quah, 3 years later. Here is the Sah Quah arises in Sitka. Herring also says that this case was engineered by the white establishment in Alaska to try and eliminate or reduce the claim of Tlingit tribal sovereignty. The court appointed the United States Attorney to represent the tribe and to argue that because the tribe was a tribe within Indian country, because its laws applied to its domestic matters, the tribe could have and control and allow for slavery when, even though it was illegal under United States law. Well, the 13th Amendment prohibits slavery throughout the territories of the United States. I think that pretty much says it all. You really don't have to determine whether a tribal government has the power to allow slavery or not. But undeterred, the Sah Quah court went on to decide exactly that, because the argument had been made that the tribal government could honor and enforce slavery among its people. Herring says actually in the trial, and he recites the transcripts and the discussions of the time in the papers, that the slave, Sah Quah himself said, no, I'm not a slave, that man is my father. And other elders testified, no, there's no more slavery among the Tlingit. But that fact did not persuade the court. So, the Sah Quah case says this. Lafayette Dawson was the judge, a newly appointed judge, because this was 1884 was the origin of the United States territory, when Alaska became a territory. And so the court is fairly new in 1886. He discusses Sah Quah. It was held that the District Court of North Dakota of Dakota had no jurisdiction to try and punish the Crow Dog for the murder of a member of his own race because he had been or was able to be punished by the local law of the tribe. But does that rule and does the rule in that case apply to the Indians of Alaska? I think not, and for various reasons. I think not. This is one person thinking this and writing it down. The United States has at no time recognized any tribal independence or relations among these Indians. Well, yes, they're uncivilized tribes. Has never treated with them in any capacity, but from the every act of Congress in relation to the people of this territory, it is clearly inferable, not directly, but inferable, that they have been and now are regarded as dependent subjects, amenable to the penal laws of the United States and subject to the jurisdiction of its courts. Now, I got to tell you, dependency of American Indians had never had anything to do with making them subject to the laws of the territories or the states. It was their possession and position on Indian country that prevented the states from exercising jurisdiction over them. Upon a careful examination of the habits of these natives, of their modes of living and their traditions, remember racism as an element and of Walter Echohawk's analysis, I am inclined to the opinion that their system is essentially patriarchal. Is that correct? No. The system among Klingon Indians is matriarchal. So this is completely wrong. And not tribal. I have no idea what that means. I mean, why would that be the case? You could have a matriarchal organization of tribes, within tribes, as we understand that term in its application to other Indians. So, the Klingons are now not tribes. They have no jurisdiction because they are not deemed to be within the scope of federal Indian law by the decision of Lafayette Dawson in 1886. And nobody put up $1,000 to get this to the Supreme Court. So that became the law in Alaska for several decades. Indian tribes in Alaska do not exist, and they do not, even if they do, they don't have any power. Until Alaska Pacific Fisheries versus the United States in 1918. Now, there's not much in this case about this in particular, about the scope of tribal sovereignty in particular. Professor Langdon mentions this judicial recognition of the Metlakatla Indian tribe, so I mention it here. And the Supreme Court looks at the claim here, and Professor Langdon went over it, but the Annette Indians had gone to Congress and gotten their reservation extended to 3,000 feet from shore, and they built a fish trap in it. Well, and Alaska Pacific Fisheries actually built a fish trap within the 3,000-foot area from the reservation. The question was, could Alaska Pacific Fisheries put their fish trap in this land, or was it prevented from doing so by the reservation? After their settlement, and before their reservation was created, Justice Van Deventer says in the Supreme Court, the Indians, under the guidance of a noted missionary, adopted a form of self-government suited to their needs. Now, the Supreme Court in 1918 has no problem saying that the Tsimshian Indians have adopted a form of self-government, unlike Judge Dawson in 1886 that says they couldn't. And now this is a reservation, there's different facts and so forth, but this is the beginning of the recognition in Alaska that Alaska indigenous peoples have rights of self-government. So suited to their needs, established for themselves a village and substantial dwellings, schoolhouses, land and the like, and constructed and installed an extensive establishment where they can salmon for the market. And Professor Langdon went into great detail as to how significant that is for the Tsimshian Indians of Metlakatla today. And it has been now, just about 100 years since that decision was made. So my conclusion here really is the same as Walter Echohawk's, and in fact I draw on it when I've written about it. But I want to draw your attention to the last quote here. This is Oliver Wendell Holmes, who wrote the History of the Common Law before he joined the Supreme Court. He said of the common law, the life of the law has not been logic, it has been experience. the felt necessities of the time, the prevalent moral and political theories, intuitions of public policy, not knowledge, intuitions of public policy, avowed or unconscious, even the prejudices which judges share with their fellow men have had a good deal more to do than syllogism or reasoning in determining the rules by which men should be governed. I'll suggest to you that phrase aptly describes the arc of federal Indian law under the common law. And so my conclusion from this is, and I'm going to, I guess, look at it from our book, that absent a specific treaty or statute, the relationship between the federal government and the indigenous peoples rests on 6 words in the United States Constitution: regulation of commerce with the Indian tribes. That's a source of congressional authority to act a lot of statutes encompassing the entire field of Native American affairs. But in an even broader sense of plenary power that Walter Ecclehawk discussed too. But as noted earlier, much of federal Indian law is the product of the common law. It is not a product of any constitutional provision or any other provision of normative principles. It is made up by judges, often guided by their prejudices, as Oliver Wendell Holmes has noted. Thus, unlike the taking of private property, there is no Fifth Amendment requirement for compensation for the extinguishment of indigenous land claims, as in the Tian case, again, by common law. Indian tribes are mentioned in the same constitutional clause as foreign nations and the several states, but under the common law decisions of the United States Supreme Court, they do not have the political independence of foreign nations, and under the United States Constitution, they do not have the domestic political status of states. They are domestic dependent nations. As Indians not taxed, the indigenous peoples in the United States, along with the slaves, were originally excluded from the calculation for apportioning representatives to Congress among the states. It took a civil war to prohibit slavery and embed the human rights of the former slaves in the 13th and 14th Amendments to the Constitution. The rights of the Aboriginal peoples of Canada are more recently embedded in the Canadian Constitution in 1986 as a provision that protects Aboriginal claims. Several preeminent commentators, including Walter Ecclehawk, concluded that the 2007 United Nations Declaration on the Rights of Indigenous Peoples provides a normative basis against which to measure and reform some of the principles of federal Indian law. We are looking here for a guidance, a principled reason for determining the rights of people, the human rights of people. And I will suggest to you the common law of the United States doesn't do it. Thank you.
No question? Comment? Welcome.
Okay, bye. State your name if you could, please.
Hi, I'm Mary Alice McKean, and we met like about 40 years ago, and I was an attorney for legal services, and you were here, and yeah, we both look different.
Yeah, right.
You know, I was struck when you were reading the quote from Justice Marshall in Johnson versus McIntosh, how ironic his statements were.
Oh, yeah.
You know, I mean, he seems to acknowledge that these weren't valid concerns.
Well,
I mean, how sensitive he was. I mean, maybe not in the original, result, but usually these statements are kind of bombastic about the superiority of, the conquering races. But he seemed to understand it was sort of all kind of BS. So,
yeah, I agree with that. But also, it's kind of what Walter Ecclehawk had pointed out as being an apology. he's saying, oh, well, it's kind of crazy, and he has other language in Worcester versus Georgia, and he said, did these adventurers, by sailing along the coast, acquire justifiable claims or right claims from the Atlantic to the Pacific for the discovering nations? Seems ridiculous. But we have to move on because power, war, conquest create rights on which we are now powerless to oppose. And so it's an apology in a way, and Walter talks about this as it being a characteristic of all these terrible Indian law cases. They start off apologizing.
Sort of like our hands are tied.
Yeah, oh, too bad, and and then bang, here you go. You don't have any more property by the time you get to the end of the clause.
There's a case that got highlighted by the podcast, This Land.
Say again?
There's a case that's up in the Supreme Court that was highlighted by the podcast, This Land.
Okay,
It deals with,
give me a lot of background because
Okay.
I don't keep up much.
it deals with some kind of murder, and part of what's in dispute is where the murder occurred,
yeah.
and if they need to honor like a 100 or 200-year-old treaty
Yeah,
that the United States or Oklahoma or whomever had just ignored.
yeah.
Supreme Court heard oral arguments about it this past year, and then they didn't decide it. They did the unusual step of putting it off
Yeah, good
to make a
sign.
decision. And it just seems like a lot of the cases you talked about, because of the distance of time, or whatever was going on, like a lot of these judges just got away with making things up.
That's true, particularly in Alaska, because they could not. It was very difficult and costly to appeal anything.
And so with this case that's pending a decision now, I guess, it feels like they can't get away with just making things up if there's a concrete treaty on the books that has the words that have a plain meaning. Like, do you have any take on how the U.S. Supreme Court is going to resolve?
Sure. Well, you'd hope that, as Walter also often said, that the court would do justice. It would really consider what the facts in the law are and reach a conclusion based on justice. I don't know what the facts of this case are, but all too often, I mean, they find an excuse not to, because they are more persuaded by the policies, the intuitions of policy. Intuitions, my God, not even thought, just intuitions of policy is what Oliver Wendell Holmes thought courts would often do. So I don't mean to, I'm not going to just knock the U.S. Supreme Court. I would hope they'll do the right thing. And if there's a 200-year-old treaty that says the tribe will continue to have jurisdiction over these matters, then hopefully they'll decide the right thing. But I'm not sure familiar with the case. Is anybody else here familiar with that case? You are, yes, right. So tell us about it. But you'd have to come up, though, I'm sorry. You have to come up to the microphone. So maybe, yeah, okay, yeah, Fred, go ahead.
Good morning or afternoon. I'm Fred Treem, and you'll probably remember me because we've argued on opposite sides of the Supreme Court.
Yeah.
It's been a long time.
It's been a while, yeah.
And David, I have a question about common law reception statutes. Alaska is one of the 49 states in the Union. The one state is the obvious exception that have common law reception statutes that are common law jurisdictions.
Why don't you explain what that means? Why don't you explain what a common law reception statute is?
I should or I don't have to.
No, maybe not to me, maybe to me, but everybody else here might want to know what it is. Does that mean they receive the common law from other states? And that, yeah. Right, okay.
The Alaska common law reception statute is in Title I. It's one of the first statutes in our statute book, AS 01.10.010. I committed it to memory decades ago, but basically it just says that Alaska, the common law shall be the rule of decision unless there's a statute or a legislative decision to the contrary.
Right.
So I kind of wonder out loud then, when we look at this ancient case from 1886 in Sah Quah, that probably qualifies as it's a decision of a common law court.
Right.
And is that part of our common law, and is it received by our reception statute?
Right. Well, it's part of the territorial law, and it would be the common law of Alaska if it was still good law. But it has been superseded. I don't think it's ever been overruled, but it has been superseded by numerous cases in the state Supreme Court, notably, which, beginning with John V. Baker in 1999, hold that Alaska Native tribes have jurisdiction over their members, even outside of Indian country. That case, although it was part of the common law, is overwhelmed by other cases that became part of the common law as well. And that's the confusing thing about Alaska legal history, is you have this era of cases being decided that are just inconsistent with the basic principles of federal Indian law. They are the law at the time and for the time that they exist on the books, and you can't tell whether they're really, no one overruled it as a federal district court, except I think Venati, the Ninth Circuit decisions, they describe these decisions as antiquated. So I don't think it is good law today. I think that the fact that Tlingit and Haida Central Council is recognized as an Indian tribe, has its own court, and exercises jurisdiction over its people and its affairs, supersedes this decision.
And could I have a part two to my question?
Of course.
Thank you. The law of corporations is a wonderful collection of common law rules, and I'm wondering if you could explain to us how did Congress choose the corporation as the vehicle by which to convey money and land to Native corporations when it made that choice in 1971 in ANCSA? What was the reason why?
Is buried in the mists of memory. A reminder to Bismarck's aphorism about making laws. If you've ever seen sausage or laws made, you would want nothing to do with either one of them. But there were a number of forces, as I understand the history, and I've heard it described before. Alaska Natives did not want an Indian tribal settlement in some ways, many ways. Some did. Their voices were not heard. And they wanted something that would be free, and they'd have an independent control over it in the way that the rest of America has control over their institutions. Congress was not about to listen to a reservation settlement either in 1971, late 60s. They were not about to listen to this, having a reservation kind of settlement in Alaska. It was just before the self-determination era began. It was kind of at the end of the termination period of American Indian policy. There was no desire in Congress to set up a reservation system. And that's one of the first provisions of the Claims Act, of course, is to eliminate any true lengthy trust or reservation system of government. So I think in Congress, just reading between the lines, Congress didn't want it, didn't want a reservation system. There was support among Alaska Natives for a corporate kind of settlement, but others might have to address that who were there and have more knowledge than I do.
And that's a good segue for me to ask to be excused, because about a week from now, another client or former client of mine, Emil Nadi, is going to come, and I think he did participate.
Better source of information than me, I can assure you.
Well, I'll repeat the question next week.
Okay, all right.
Thank you.
Could we have it explained? Do you want to explain this case a bit? Well, sometime when we have it, maybe. Sorry. Come ahead. Go ahead.
I just had a quick question. It's often said that ANCSA extinguished Aboriginal titles in Alaska, and there's some discussion in these cases of Indian title. Do you see any difference between those things?
It's the same thing.
The same thing.
Yeah. Indian title, Aboriginal title is an exclusive right of use and occupancy. That's the kind of title it is. It's not full fee title. It's right to use and occupy the property, but it is exclusive. Nobody else can interfere with your right. So you have to extinguish that before you can actually grant anybody else an interest in the property. The United States has to do that. Does that answer the question? Okay.
With regard to the case that's involved in the podcast, this land, it's a Cherokee tribe in Oklahoma. There are 5 actually treaty tribes.
Yeah.
But anyway, a murder took place. At first they thought it was not on a reservation, and so the state authorities prosecuted the defendant, convicted him, and sentenced him to death. Then one of the lawyers working for this defendant did a little digging and found that the murder site itself wasn't exactly where it had been thought, and that actually the murder site is on the reservation of a band of Cherokee Indians. And so they appealed, saying you can't, and the tribal government has no death penalty. So it's really tried to help this defendant avoid the death penalty.
Yeah.
But the state of Oklahoma in that case has made the argument that this reservation no longer exists because it hasn't been honored by disuse. The reservation just doesn't exist anymore. Great parts of Tulsa are part of this
Oh, I
reservation.
didn't get it.
And so last year, it was argued before the Supreme Court. It was scheduled for decision this June. The Supreme Court set it off again. I believe they asked for re-argument, but at least they set it off and decided not to decide it last year. I think it's probably going to be re-argued this year, but that's what the case is about.
Thank you very much. It sounds close, maybe, but I don't think you abandon a reservation once it's created unless Congress terminates it. But we'll see what the court does. Are we done here, Sah?
Just one question, please. I'll make a few comments. I'm from Wrangell, and that's where I heard you mention. I'm sorry I missed the first part of your lecture.
It'll be on YouTube.
Yeah, and that's where the author of the Teton case came from, Wrangell. Our beloved leader, William Paul,
Yes, right.
and his brother, Louis
Right,
Paul,
Louis
they
Paul,
were
yeah.
responsible for politicizing the Alaska Native Brotherhood.
There you go.
And my uncle, Raymond James Goodlow, my namesake, he seconded the motion in Haines A&B Grand Camp Convention in 1929 to pursue the land claims. Anyway, when you mentioned the Teton case, it brought up memories of what the elders told me, and that was that they were the smallest clan, Teton, but they had all the land, a lot of land that they controlled. And some of it was on Prince of Wales Island, on the north part. And I was just going to reiterate that first question. If you had any comments on the Teton case, or I could give you more of what I reflect.
Well, I think you might have more to say about it that would be interesting than I do.
Oh, thank you. I don't know. I told somebody that the elders told me, somebody told me that the reason the Teton case didn't hold as far as being brought into a law was because it didn't deal with the whole picture of Alaska, that it was just a clan property request or pursuit.
Well, I have always been impressed by footnote 17 in the Teton case. Footnote 17. So I think that's the right number, if you have a chance to look at it. In which, after all this discussion about Aboriginal title or not, and compensability or so forth, the Supreme Court noted in a footnote that it would cost, I believe the figure was, $7 billion to pay for Aboriginal title. So we're not going to do that. It's too much money. So I wondered if that was actually the basis of the decision. That it was just going to cost too much money. And so we'd find a way to not do it.
Yes. Yeah, I also thought I heard that William Paul was one of the guys that offered to give up the Aboriginal rights or the hunting and fishing rights. But I don't know if that was
It's a
true.
great trying time for many, many decades for Indigenous peoples in Alaska when their lands were under threat by statehood selections and other interests. It is hard to second guess an advocate in that position.
Yeah, I'm sure it was real dynamic times. Just to finish up here, when they went to Washington for the land claims, the start of the pursuit of the land claims, and when it came time to divvy it up, I heard that Congress gave all the communities that were pursuing 48 hours to hash it out. And that's why places like Kenai, that's heavily populated at the time, and they got urban status, and Wrangell got left out.
Yeah.
And
Yeah, I know there was a sort of a crunch at the end to approve it with Nixon on the phone and everything, but I'm not sure if that's what you're talking about either. But it is not, the Claims Act is not, as often usually is the case in Canada, a negotiated settlement with Indigenous peoples. It was a settlement worked out with leadership at the time, but the congressional method of doing it was not to negotiate, it was to basically give an ultimatum. And that's the fact that they were faced with, I think. There could be better ways of doing claims acts and settlements. I think there are in Canada. But Dennis, yeah.
I have a question about the Johnson versus McIntosh. I can never get straight which was which in that case, but I'm thinking of a statement made by a professor at UCLA in a book that he'd written on Indian land losses. A point he made was that whites always acquired land according to the law, but he said they also made the law. And in case-by-case basis, the terms fit whatever it was their needs were. As I understand it, in the Johnson versus McIntosh case, one party obtained the land through the federal government, the other through directly from the tribe, and the decision was in favor of the party that received it from the federal government. I also understand that the implications, if it went the other way, would have established enormous rights for Native people. Could you comment on what would have happened had the case gone the other way?
All hell would have broken loose. Yeah, by the way,
I just want to note that, I think that in that case, again, that the decision favored the Native the white community.
yeah, of course it did.
I mean, I think it was contrived to do that.
There is some evidence that the Johnson versus McIntosh was contrived and brought up as a case to enable the Supreme Court to clarify land titles in the United States in favor of land titles granted by the federal government, and to prohibit land titles being granted by Indian tribes that would be of any success. Marshall has said in the decision, if the plaintiffs want to have their title confirmed, they should go to the Indian courts, the courts of the Indian tribe, and have the Indian tribe enforce its title. But in the United States courts, we're going to enforce the United States title. That's maybe a cynical way of looking at it, but of course, if he had decided that the Indian tribes had the right to grant title to people independent of the United States, that would have opened up the whole, calls into question the legitimacy of titles granted by the United States. It would have probably been a constitutional crisis for the United States to do that. But it might have been justice for the Indian peoples. But no, these decisions are, on the bottom line, when push comes to shove, if you're going to have a fundamental interest of the United States, I don't mean a justice interest, but a fundamental economic interest of the United States pitted against the just treatment of an Indian tribe, it's going to come out in favor of the United States. That is, I think, the lesson of history. There are some cases like Crow Dog, where the Supreme Court takes a hard look at it and says, well, gee, murder, but the tribe had the authority to do this. We're powerless here. And they went out of their way, actually, to say that the Indian country statute that had expired by common law, they say, now, this is the court doing this, took a statute that had expired, and by their own decision, which now becomes a common law decision, based on the justice's view of what the history means, that statute, now by the decision of the Supreme Court, the Indian country statute, is being applied, whether it's expired or not. As a principle of common law, the Indian country statute in Crow Dog was extended from and confirmed to cover everything west of the Mississippi. And that was in 1883, long after 1867, when the United States had acquired the interest of Russia in Alaska. So that decision was maybe a courageous decision, maybe it was a decision that said, look, this is what we're going to do, and you're going to have to fix it in Congress, and Congress did the next year. But so you have decisions like that. I mean, U.S. v. Winans, the same person, the same justice that decided the Alaska Pacific fisheries, Justice Van Deventer, upheld the treaty rights in 1916, I think it was, before Alaska Pacific fisheries, to the fish in all of the rivers in Washington State. That he upheld the right of the Indians to fish at their usual and accustomed places, outside a reservation or in a reservation, as a matter of the treaty rights of the Indian tribes in Washington State. The Supreme Court upheld that. And that began the Washington Treaty fishing rights cases and a whole dispute over what amount of fish the Indians were entitled to, which was eventually decided to be 50%. So you have cases from the Supreme Court that do reach inconvenient but just decisions, I think, for Indian tribes. Not all. And by the way, Dennis is a person I value greatly as a mentor and a leader, and this is Dennis Demmert. So thank you very much for all you have meant to me and my family and my life. Thank you. All right.
Thank you again.